Hi, I'm Professor Mark Grabowski. In this video we'll discuss the basics of media law. If you're in my media law class, this video will offer an overview of some of the topics we'll be covering in depth this semester. And if you're in my journalism class, this video will act as a basic guide to the most common legal issues you'll face as journalists. There's a lot to cover, so let's get started. There are 7 big issues we'll be talking about today. Censorship. Is the government, or if you're a student journalist, are school officials ever allowed to prevent you from publishing something or saying something on a newscast? Libel. What happens when you defame someone, when you publish a statement that isn't true? Invasion of privacy. Are there ever certain pieces of information that are too private and shouldn't be allowed to be made public? Copyright, which is sort of like plagiarism. Not exactly, but what happens when you copy someone else's work and don't have permission or don't give them credit? Access to information. What records do you have access to? Are there any records that are off limits? And what can you do if someone tries to keep you from accessing information that you believe you should have access to? For example, if you go to cover a city council meeting and they say no reporters allowed, is that okay? What sort of redress do you have for that? Reporter's privilege, which basically concerns protecting anonymous sources. And finally, the internet. Do these laws, these principles I just mentioned, such as copyright, invasion of privacy, do they apply to the internet, to online journalism, and how? What about bloggers? Do they have the same rights as journalists? And we'll cover each of those topics in turn. Note that we'll be discussing those topics in the context of the laws of the United States. So, we're not interested in, what are the laws for journalists in Canada or the United Kingdom or in Zimbabwe or Egypt or anywhere else. We're just focusing on what is the law as it pertains to the media and journalists in the United States. And a lot of people take freedom of speech for granted in this country, but we're actually in one of the few countries in the world that recognizes the value of free speech and a free press. When America was founded, it was called by some, quote unquote, the Great Experiment, the new American system, a government of the people, by the people, and for the people, had never been tried before. It was intended to be a limited government controlled by the people governed instead of the other way around. As part of the founders' plan to ensure that individual freedoms would be respected, they enacted the Bill of Rights, the first 10 amendments to the United States Constitution. The very first of those amendments restricted the government's right to enact laws that interfered with 5 specific individual freedoms: freedom of religion, speech, press, assembly, and petition. Though the First Amendment contains exceptionally strong language limiting government interference of these freedoms, the amendment begins, quote, "Congress shall make no law," end quote. We have come to accept that the rights protected are not absolute. At times, the freedoms guaranteed by the First Amendment can conflict with other important rights or obligations, and a balance between the two must be reached. For example, because of the threat to public safety and concerns about the general welfare, it's been famously noted that there is no free speech right to scream fire in a crowded theater. As we'll talk about later, there is also no First Amendment right to publish libelous statements or material that invades another's legal right to privacy or that infringes on a valid copyright. Still, the First Amendment remains an ongoing promise by our government that, but for exceptional reasons, it will not interfere with the right of its people to engage in freedoms deemed so essential. If you go to another country, you likely won't enjoy the same press freedoms that we enjoy here. Okay, so let's talk about this in a bit more detail. First topic is censorship. It's important to understand that the laws are different regarding censorship depending on what type of journalist you are. Professional journalists enjoy much more freedom of speech than student journalists. And By professional journalists, I mean, for example, reporters at the New York Times, CNN, ESPN.com, and even the Poughkeepsie Journal. These journalists are rarely censored by the government or authorities. The Supreme Court, which is the highest court in the United States and has the power to overturn government laws and decisions it deems unfair or unconstitutional, has said that injunctions preventing the exercise of speech, or censorship in other words, should be viewed skeptically, that they carry, quote, a presumption of unconstitutionality, end quote. Now, professional journalists may get in trouble after they've published something, but rarely will the government come in and stop a report from being published. And the reason they don't do that is because the U.S. courts have consistently prevented this type of censorship, which is known as prior restraint. So if the government tries to keep the New York Times from printing something about George Bush, or the Poughkeepsie Journal from printing something about one of its city officials or someone at Marist College, those newspapers can go and appeal to the court and they'll likely win. Now, there are some exceptions. Sometimes judges will allow censorship in certain situations. For example, a judge can issue a gag order on the press for trials. This typically only prevents the media from reporting on a case before it starts, and the reason for this is that they don't want to bias potential jurors. They want to ensure that a defendant receives a fair trial. But once the court case begins, the media can print whatever they want. Another exception, or another time that censorship is allowed, is military operations. Journalists may be required to have their stories from Iraq, for example, screened by military officials in order to ensure that they're not revealing any information that could compromise a military operation there. So just to reiterate, professional journalists can get in trouble after the fact, if they publish something and it's deemed to be libelous or an invasion of privacy or something like that. But generally, they are not prevented from publishing something. So if you know, for example, that a newspaper is going to publish something about you that you don't like, that you don't want in the newspapers, it's going to be very hard to get a judge to issue an injunction, decide with you, and issue an injunction telling the newspaper editors, no, you can't publish this. You'll have to wait until after it's published to go and seek damages against the newspaper, to take them to court and sue them and try and recover some sort of damages. Now, as far as censorship goes, it's a different story when it comes to the student media. And when I say the student media, I mean high school newspapers, college newspapers, college radio stations, things like that. Censorship by school, college, and university officials is allowed. The extent varies depending on the level of the school. Generally, college students enjoy much greater free speech protection than high school students. In the court's view, college kids are more mature, so they can better handle controversial speech. High school students, on the other hand, need more coddling and protection from offensive speech, so greater censorship is allowed by school officials at the high school level and certainly at the junior high and grade school level. At the college level, there's sort of a dichotomy. Except for a few exceptions, the courts have generally prohibited college officials from controlling the student newspaper and from preventing student newspaper from publishing content that they object to, that the school officials don't like. However, college officials have much greater control over campus broadcast stations than they do the print media, and that's because the former broadcast stations require a broadcast license from the Federal Communications Commission, or the FCC, and the school, not the students, usually owns the license. It may seem like censorship, and well, it is, but it is arguably a good idea because the FCC imposes huge fines on radio and TV stations if they broadcast curse words during certain hours, for example. If a college radio station airs bad language and the FCC imposes a stiff penalty, who do you think is going to foot the bill? Students? No, the colleges. So due to liability reasons, more censorship is allowed of college radio stations than of college newspapers. If the Circle, the student newspaper at Marist College, goes and publishes a bad word in the newspaper, for example, the government won't go and impose a fine on them. However, if someone on the college radio station drops the F-bomb, they can be fined. And speaking of Marist College, which of course is a private college in New York, it's important to note the distinction between the legal protections available to students attending public schools versus those enrolled at private schools. Okay? The First Amendment only prohibits censorship by government officials, not by private individuals. Because private school administrators are not classified as government officials or as state actors, as school officials at public schools are, private school officials are not bound by the same constitutional limits as their public school counterparts. It may come as a shock to some to hear, then, that the First Amendment does not generally prohibit censorship of private school student media, and that includes colleges like Marist College. So private schools, whether it's a Catholic grade school or a private college like Marist, can pretty much do whatever they want. If Marist wants to censor its school newspaper, The Circle, they can do that and the students can't stop them. However, if the State University of New York, or SUNY, wants to censor its student newspaper, it can. And the reason for that is because SUNY is a public university. Okay, it's a state school. But private schools can basically do whatever they want when it comes to regulating the student media. The understanding is that no one's forcing students at private schools to attend their private school. That's something that they sought out or their parents sought out. So in your case, because you decided to attend Marist College instead of going to your state university or local community college, you have to abide by Marist's policies and rules if you want to go there, if you want to be a student there. And those policies and rules may include limitations on your free speech. So if we're talking about a private school, be it a grade school, high school, or college, the First Amendment doesn't apply. The good news, however, is that many private colleges do value free speech. They see the unfettered exchange of ideas as being critical to their educational mission, and they're consequently reluctant to censor speech even if it's controversial or offensive. In fact, a lot of private schools have adopted policies basically providing the same rights that the First Amendment does. And I think that's also why you see so many colleges, including Marist, have resisted blocking websites such as the infamous juicycampus.com from campus, even though some students would like to see that happen, because they don't want to be seen as censoring speech. Now, when it comes to public schools, a fair amount of censorship is allowed below the college level. So at high schools and elementary schools and junior high schools, for instance, school administrators are allowed to go and impose a lot of speech restrictions. Probably the biggest case involving student free speech rights is Tinker versus Des Moines Independent Community School District. It was decided almost 4 decades ago, but it's cited in almost every legal opinion involving student free speech rights, even today. Now, this case, which is sometimes referred to simply as the armband case, began back in December 16th, 1965, when Mary Beth Tinker, who was then a 13-year-old student at Warren Harding Junior High in Des Moines, wore a small black armband to her 8th grade class to protest the war in Vietnam, which was going on at the time. Over half the school day passed quietly and without incident, and just before her afternoon algebra class, however, Mary Beth was called to the principal's office and ordered to remove the armband. She did so. The principal then suspended her and sent her home for violating a quickly enacted school board policy prohibiting armbands. Eventually, the school suspended a total of 5 students, including Mary Beth's brother John and one of her friends, for wearing armbands to school. After the school board refused to overturn the ban on armbands, and following heated debate on both sides, the 3 students and some other students sued the school district. 4 years and 2 courts later, in 1969, the United States Supreme Court handed down its decision. By a 7-2 vote, the court ruled in favor of the students. In a famous line from its decision, the court said that neither students nor teachers, quote, shed their constitutional rights to freedom of expression or speech at the schoolhouse gate, end quote. The court, however, recognized the unique nature of schools and the legitimate concerns of school officials in maintaining a productive learning environment. To the extent that school officials interfered with the right of students to express themselves, the court, as it usually does in such cases, created a balancing test to analyze and weigh the competing interests. The balancing test the court came up with, now widely referred to as the Tinker Standard, is this. Students have the right to engage in free speech activities while they're at school, as long as their speech is, first, not invading the rights of others, and second, not creating a material and substantial disruption of normal school activities. In other words, under Tinker, before school officials can censor student speech, they must first show that the speech is unlawful, for example, that it is libelous, obscene, or invades a person's legal right to privacy, things like that, or that the speech would create a serious physical disruption that would prevent regular school activities from going forward. For example, an article in the school newspaper that seriously encourages students to engage in a class walkout or a school demonstration, and that provides specific information regarding when, where, and how such an action should occur, could be considered materially disruptive and not protected under the Tinker Standard. On the other hand, Tinker's disruption standard does not prohibit speech that is merely controversial or that causes hurt feelings or heated debate. So this Tinker Standard, which has been used to or been applied to school newspapers at grade schools and high schools, provides a significant, though not an unlimited, protection and creates a meaningful hurdle that school administrators must overcome before they can legally censor. Tinker remained the sole standard for analyzing student media censorship cases for about the next 2 decades, so up until the mid-1980s. During that time, the lower courts applied the Tinker Standard to a number of situations, specifically involving high school student newspapers and other student media, and in most of the cases, the administrative censorship was struck down as unconstitutional. But in 1988, the Supreme Court addressed the question it had never specifically answered before. What First Amendment protection do high school students have when working on school-sponsored publications like a student newspaper? In the spring of 1983, students working on the Spectrum student newspaper at Hazelwood East High School just outside of St. Louis decided to publish a special 2-page section in their school newspaper that would focus on some of the hot issues facing teens at the time. The section included 2 articles, one on teenage pregnancy and the other on the impact of divorce on students, that resulted in the principal pulling the entire special section from the newspaper. The articles contained no unlawful speech, nor did school officials claim that the articles would have caused serious physical disruption to the school. Rather, the principal claimed he censored the articles because, among other things, he felt the topics were, quote, inappropriate, unquote, for a high school audience. When neither side backed down, the student sued, and after about 4 years in lower courts, the case eventually made its way to the U.S. Supreme Court, which decided to hear the case and ended up handing down a decision that surprised and disappointed many First Amendment advocates. Rather than simply applying the Tinker standard to the case, which almost certainly would have meant a victory for the student journalists, a 5-person majority of the Supreme Court justices concluded that the facts of Hazelwood were significantly different than those considered in Tinker. Mary Beth's armband, the court said, was private or independent speech. She made the armbands and wore them all on her own. The student newspaper at Hazelwood High School, on the other hand, was funded by the school, produced as part of a journalism class, and overseen by a journalism teacher paid by the school. It was, the court said, school-sponsored student speech closely associated with the school itself, which the court concluded fell into a different legal category and required the application of a different legal standard. The standard announced by the Supreme Court was much different from the standard announced in the Tinker decision. Instead of allowing school officials to censor speech only when it was unlawful or seriously disruptive, the court said that high school officials could censor some school-sponsored student speech, including the school newspaper, when they had a reasonable educational justification for doing so. The specific phrase the court used was that censorship would be permitted where it was reasonably related to legitimate pedagogical concerns. That's obviously a much lower barrier to censorship than what was established by Tinker. Predictably, Hazelwood has led to a sharp increase in the censorship of high school student media. Now, while Hazelwood was undeniably bad news for high school student expression, there are some important exceptions to its limitations. First, Hazelwood only applies to school-sponsored speech. Independent student speech, such as the political armband like Mary Beth Tinker's, or an independent or underground student publication produced by students with their own resources outside of school, continue to be protected by the higher Tinker standard. Second, Hazelwood does not apply to student media where students have been given the authority to make their own content decisions, either by a written school policy or by an established practice. Such student media organizations are considered public forums and are also protected by Tinker. Third, even under Hazelwood, school officials must demonstrate that they have a reasonable educational justification for their censorship. They cannot censor something for no reason or simply because they disagree with the viewpoint it expresses. And there have been cases where the court has found that school officials have failed to meet the Hazelwood standard, and they've ruled in favor of the students. Finally, following Hazelwood, some state lawmakers concluded that the Supreme Court had gone too far in restricting the free speech of students. While states can never pass a law that provides less free speech protection than the federal First Amendment, they can always pass a law that provides more. And so far, 6 states, Arkansas, California, Colorado, Iowa, Kansas, and Massachusetts, have passed so-called anti-Hazelwood laws that give back to their students much of the same protection they had under Tinker. Students in Pennsylvania and Washington may also have additional protection in the form of state regulations. And local school boards across the country, often prompted by student demands, have passed district policies limiting administrative censorship. So that's censorship in a nutshell. Next up on our list of the most commonly faced legal issues by journalists is libel. And it's a topic that many journalists, whether they're student journalists or professional journalists, find complicated. While the law can get complicated for lawyers and judges trying to sort out the details after a libel lawsuit is filed, the basic idea of libel, which is enough for journalists to protect themselves from most lawsuits, is fairly straightforward. So what is libel? Well, here's a definition. Libel is the publication of a false statement of fact that seriously harms someone's reputation. So basically, if you go and publish something that is untrue. Here's an example. If you publish a story in the Marist Circle that says Professor Strudler, who is the chair of the communication department, if you say Professor Strudler stole a school van and used it for a family vacation this summer, you'd better be right. If you're wrong, you probably have seriously harmed or libeled Professor Strudler's reputation. It's not too hard to understand, right? Well, we need to dig a bit deeper so you can fully understand this idea. Within this one-line definition are 5 things that the person suing, in this case it would be Professor Strudler, must show before he can successfully sue for libel. And the Supreme Court added one more. So let's take a quick look at each one of them. The first thing the person suing must show is that the libelous statement has been published, and that's usually pretty straightforward. It's important to understand, however, that a published statement can occur almost anywhere. News articles are common sources of libel, but libelous statements can also appear in headlines, photo captions, restaurant reviews, and cartoons. It's also important to note, at least in a print-based publication, that you can be held responsible for republishing libelous statements made by others. Letters to the editor, senior wills and yearbooks, or ads created and submitted by others that contain serious and false claims can all be sources of libel lawsuits. In addition to showing that the statement was published, the person suing must also show that he or she has been individually identified. In many cases, this is also pretty easy to determine. If a person is named, he or she will almost certainly meet the identification requirement. In other cases, however, it may not be so simple. For example, even if a person isn't named, he or she might be identified by other details included in the story. In our van example, our Professor Strudler example, for example, a story that says the head of the communication department at Marist College is being investigated for stealing a college van, that still pretty clearly identifies Professor Strudler, even though you haven't specifically or directly named him. On the other hand, the much more vague statement, college officials are investigating a claim that a college employee stole a college van, would probably not identify Professor Strudler. So publications can successfully use pseudonyms or disguised identities to avoid a libel claim, but they must use extra caution to make sure that the identification or the description isn't specific enough that you basically narrow down, or people could narrow down, who it was. So the bottom line is, if there's no identification, a person cannot successfully sue for libel, even if he or she believes that they are the one being targeted by a false accusation. So if you just publish something vague that, a college employee is being investigated and Professor Strudler, believes that you're talking about him, he wouldn't be able to win that lawsuit. On the other hand, if you publish something like the communication department chairman's being investigated, well, he could win that lawsuit because there's only one communication department chairman, and it's Professor Strudler. Okay, now the third part of the definition of libel is very clear. Only false statements of fact can be libelous. So there aren't too many black and white rules in the law, but this is one of them. Truth is an absolute defense to the charge of libel. So, if you know for a fact that Professor Strudler stole the van, then he can't go and sue you for libel because it did in fact happen. So it's not libel. Libel, remember, is publishing a statement that's untrue. But it's not quite that simple. Even though you might know that Professor Strudler took a van without permission and used it for a family vacation, do you have sufficient reliable evidence, for example, verifiable documents, police reports, photographs, trustworthy, unbiased witnesses, etc., to back your claim if Professor Strudler denies it? If you don't, you may not be able to rely on the truth to get you out of a libel jam. On the other hand, if you know something is true and you can prove it, you can never be successfully sued for libel, no matter how much it might damage a person's reputation or how angry they might be. As the saying goes, a person is entitled to no greater reputation than they have earned. Okay, so the fourth component of libel is that the person suing, in this case Professor Strudler, must show that the libelous statement is an assertion of fact and not an opinion. If a statement contains only opinion, it cannot be libelous. Unfortunately, it's sometimes difficult to tell one from the other. In our example involving Professor Strudler, it's easy to tell that the statement is an assertion of fact. For one thing, the facts are objective. They are either false or they're true. Either Professor Strudler unlawfully took the van or he didn't. If instead you had simply said, Professor Strudler is awful, that statement, which can't really be proven true or false, would be pure opinion and protected in a libel lawsuit. Some statements can contain both opinion and fact. For example, I think Professor Strudler is awful because he misused college property this summer is a mixed statement that might support a libel claim. And be careful also, simply publishing a story on the editorial page or labeling it as opinion will not protect you from a libel claim if it contains untrue factual assertions. Okay, the next component of libel is that in order to successfully sue for libel, the person suing must also show that the false statement about them caused serious harm to their reputation. Just being mildly offended or embarrassed isn't enough to sue for libel, to at least successfully sue for libel. Some statements about a person, if false, will almost always be sufficiently harmful to a person's reputation to support a libel claim. For example, if you publish a statement that accuses a person of having committed a crime, such as stealing a college van, your facts must be accurate because such accusations will almost always seriously harm a person's reputation. In the same way, accusing a person of sexual misconduct, lying, professional misconduct or incompetence, bigotry, or having serious money problems are a few other categories that should always raise a red flag. Journalists can and should cover these topics, but they should do everything they can to ensure that the information is reported fairly and accurately. Okay, so once you show all those things, so once it's shown that a statement first has been published, second, that it identifies a specific individual, third, that it's false, fourth, that it asserts a fact, and fifth, that it causes serious harm to a reputation, the person claiming libel must still show one more thing when suing in an American court. The Supreme Court has said that in order to successfully sue for libel, the First Amendment requires that the person suing must also show, at a minimum, that the journalist messed up, that he or she was somehow at fault. In other words, before you can be successfully sued, you must have done something a reasonable reporter or editor would not have done, or failed to do something a reasonable reporter or editor should have done. This means that if you always do what a reasonable reporter should do, and don't do what a reasonable reporter wouldn't do, you will never be successfully sued for libel. Alright, they might try to sue you, but they won't be successful. They won't win if you do what a reasonable reporter should do, or if you avoid doing what a reasonable reporter wouldn't do. So what does a reasonable reporter or editor do? Well, take a look at the suggestions on the screen. None of these suggestions should be surprising. Use good sources, take accurate notes, obtain documentation, be fair, be open-minded, and report all sides. Yeah, that can take a lot of work, but you know what? the law isn't kind to lazy reporters. So make sure you do all your homework, put all your work in, and do all that needs to be done. Don't try to cut corners, because you just might save yourself from a lawsuit or from getting fired. A golden rule of journalism, and one that will generally keep you out of legal hot water, is to report only what you know and to explain to readers how you know it. Okay, so that covers libel and defamation. Next up is invasion of privacy. The law recognizes that everyone has, under certain circumstances, a legal right to simply be left alone. It provides that there are certain subjects, certain places, and certain actions that are nobody else's business. On the other side, however, the law also recognizes that at some point a person's right to privacy gives way. For example, many things that people do significantly affect others, and the public, often by way of the press, has a right or a need to know about them. In the parlance of journalism, such information is said to be newsworthy. Invasion of privacy law is all about balancing these two sometimes competing interests. While invasion of privacy law can vary by state, courts have across the nation generally recognized four different types of invasion of privacy, and they are public disclosure of private and embarrassing facts, intrusion, false light, and misappropriation. We'll cover each briefly. The first category of invasion of privacy is the public disclosure of private and embarrassing facts. And this is probably the most important and most common area of invasion of privacy that comes up with the student media. The title pretty much describes the problem accurately. This type of invasion of privacy occurs when you publish information about someone that is so private, so embarrassing, and so intimate that a reasonable person would be shocked that you actually published it. The danger here is that, unlike libel, it is no defense that the information is true. Rather, it is simply that you crossed the line in publishing it. The good news is that this is usually the type of information that should set off some alarm bells prior to publication. For example, providing graphic details about a person's private sex life, disclosing that an otherwise private person has a medical condition that they've not publicly revealed before, or publishing detailed information about a person's grades when there is a no good or newsworthy reason for doing so would be examples of this type of invasion of privacy. On the other hand, information that is just mildly embarrassing or that is already fairly well known is insufficient to support a private facts claim. The primary defense to this kind of an invasion of privacy claim is newsworthiness. If information is truly newsworthy, it will not be considered unlawful. So, for example, if you just go and write a story about some random student who keeps himself having, flunked organic chemistry, that could be considered an invasion of privacy. If, on the other hand, you're writing a story about, one of the sports teams, and you say that there are athletes on the teams playing who have failing grades, that wouldn't be an invasion of privacy because that's newsworthy. The NCAA prohibits athletes from participating in college athletics if they're on probation, if they have failing grades. Also, if a person consents to your publishing otherwise private information about them, they generally cannot later claim that you have invaded their privacy. So, for example, if you're doing a profile story on a student and they reveal some sort of embarrassing piece of information to you, some sort of medical condition, perhaps they say when they were younger they wet their bed until they were age 18 or something like that, and you say, well, can I include that in the story? And they're like, oh yeah, sure, I don't care. You write about it, and then when everyone else at the college reads it, they go and make fun of this kid and call him the bedwetter, and he comes back to you and he's like, how could you publish that? I'm going to sue you for invasion of privacy. Well, no, he can't, because he told you that, and he consented to having it published in the profile story. The next type of invasion of privacy claim we'll discuss is intrusion, and unlike the other categories I mentioned, intrusion claims are not based on what you publish, but rather on how you obtained or gathered the information in the first place. Again, the idea is that there are certain private places that should be off limits to others, including reporters, unless a person has given you permission to be there. So, for example, bedrooms, bathrooms, locker rooms, or a private office would all be common examples of a private space where a reporter could be found to have invaded someone's privacy if they went in without permission, or if they used a secret listening device or camera to peek inside. On the other hand, other places are clearly public: a public sidewalk or street, a public park, a courtroom, and reporters generally have the right to report on or photograph anything that happens in such places. Other places fall somewhere in the middle of it, and it's sometimes left to a court to decide how public or private the space is. The key question in such cases is, does the person in such a place have a reasonable expectation of privacy? If not, there can be no successful claim. Newsworthiness and consent are also the primary defenses to an intrusion claim. Though in obtaining consent to enter an otherwise private space, it is important to make sure the person giving consent has the authority to do so. It's also important not to lie or misrepresent oneself in order to obtain consent. So, for example, you cannot go and pose as a pizza delivery guy in order to get inside of someone's house, or if someone has a friend staying with them, and that person says, "Oh yeah, sure, you can come into the house," you better be careful, because I'm not sure that that person actually has the authority to let you into their friend's house. The third category of invasion of privacy claims is known as false light. Not all states recognize a false light claim because in many ways it simply duplicates a libel claim, in that the harm occurs when you publish words or images about an individual that portrays him as something he is not. A common example would be publishing an extremely misleading photo caption. For example, a photo caption that states or clearly implies that an onlooker at a Ku Klux Klan rally is a participant would certainly put them in a false light. Other common mistakes include carelessly using an old file photo to illustrate a story in a way that falsely suggests a person is currently engaged in unflattering conduct, or publishing a fake letter to the editor that attributes opinions to an individual that he does not hold. The final category of invasion of privacy claims is also the easiest to identify and the easiest to avoid. You can get into trouble for misappropriation when you use another person's name, image, voice, or other likeness to help sell something without their permission. The main hot spot here is, of course, advertising and commercial endorsements. If you want to use a picture of someone or their name, voice, or anything else that is identified with them in an ad to help sell something, you first have to get their permission. It's as simple as that. And it doesn't make any difference whether the person is famous or not. Everyone has the right to control how their image is used when it comes to advertising and endorsements, so you should make it a standard practice to obtain a signed model release form before creating and publishing any ad that pictures identifiable people. If the subject is a minor and money is involved, you should also obtain permission from the minor's parent or guardian. If you publish an ad created and submitted by a third party, you may want to first have them sign an agreement stating that the valid permission has been obtained and that they will be responsible for reimbursing you for any claims that might result if a problem arises. And once again, keep in mind this only applies to advertisements, so not to reporting news or taking news photographs, only advertisements. Next on our list of Big 7 media law issues, and one that has become especially hot with the coming of the internet age, is copyright. What can you use, what can't you use, and what can you prevent others from using? The truth is, copyright law can get a bit complicated. Lawmakers and courts have tinkered with and muddied the rules a number of times over the years, and many of the rules weren't so clear to begin with. Still, the ideas behind copyright law are pretty easy to understand and can help a great deal in recognizing where today's legal lines are drawn. creating a system of copyright protection was actually deemed so important to the development of a strong, healthy society that it was specifically included in the U.S. Constitution more than 2 centuries ago. At its core, copyright law is about encouraging progress. The framers believed that a society can only flourish where there is a steady advancement in its arts and sciences. To bring about such advancement, copyright law, in its most ideal form, tries to balance two sometimes competing interests. First, copyright law recognizes that it is important that artists, authors, and other creators be recognized and fairly compensated for their efforts. Most writers would be unwilling and financially unable to spend 2 years working on the next great American novel if, once they were done, anyone could run down to a copy shop, print off or scan 5,000 copies, and sell their bootleg version to others on the internet at 75% off the regular price. Second, copyright law recognizes that encouraging people to create new works will do little to benefit society if others are not permitted to discuss and learn from them. Progress requires a system that allows others to share information and to build on the work of others. So what can be copyrighted? The list is long, but it's not unlimited. In order to qualify for copyright protection, a work must be first, original, second, it must be fixed in a tangible form, and third, the work must show at least a minimal amount of creativity. These hurdles are not especially high and allow for copyright of most things that people create, such as photos, articles, paintings, cartoons, music, and videos. In fact, there are even special shelves in the United States Copyright Office in Washington, D.C. that hold samples of copyrighted wallpaper. There are, however, certain things or categories of material that cannot be copyrighted. For example, facts and ideas, on their own, cannot be copyrighted. The Wall Street Journal, for example, does not own the fact that the stock market went up or down yesterday. Anyone can write a story about that fact. They just can't use the Wall Street Journal's exact words to do so. Also, most records created by federal government employees cannot be copyrighted. You can, for example, go to the Pentagon's website to download and use Department of Defense photos to illustrate your story on military recruiting. Unlike most images on the internet, you don't need the Pentagon's permission, though you should still give DoD photographers credit. Older works whose copyrights have expired and that have fallen into the public domain can also be used without permission. Finally, the Copyright Office has said that certain categories of works, usually because they lack sufficient creativity, cannot be copyrighted. Titles, slogans, short phrases, lists of ingredients, and alphabetical lists of names are among the things that you can usually use without permission from the copyright owner. Copyright law does protect material on the internet. A lot of people don't know this. Just because it's possible to find and download almost any image, text passage, or song that exists with one click of the mouse button does not mean it's legal to do so. You should presume that the same rules apply to the use of online material as govern your use of print-based works. So what are the rules? Well, for most journalists, here is the most important one to remember. If you didn't create the material that you want to use, or you don't own the copyright to it yourself, you must obtain permission from the copyright owner before you do. Pretty simple. But there is an important exception that journalists in particular need to know about. Remember the balance we talked about at the beginning between protecting copyright owners' rights and recognizing society's need for readily accessible information? An exception to the general copyright rule known as fair use is where that balancing act really comes into play. The fair use doctrine is, in effect, a compromise, and it allows for the use of limited amounts of copyrighted works for important purposes like news reporting, commentary, critiques, and education, so long as the use does not significantly cut into the commercial value of the original copyrighted work. For example, a newspaper can generally reprint a short passage from a new book to accompany a book review, and a TV show is usually safe to run a short clip from a movie to illustrate its discussion or review of the motion picture. Other fair uses probably include the use of a single frame from a comic strip to illustrate a news article reporting the retirement or death of the comic strip's creator, reprinting a tobacco advertisement taken from a national magazine to illustrate a story on the effect of cigarette advertising on minors, or reprinting in a news article 2 lines from a song that has sparked an international controversy. Keep in mind that the media cannot always claim a fair use. Unless their use meets the fair use criteria, which is not always easy to determine, they must first obtain permission. Still, it's essential that journalists and student journalists understand the basic of fair use and keep this important exception in mind. A few other things to keep in mind. First, it's not enough to simply credit a copyright owner's work in order to use it. For example, including the phrase courtesy of People magazine or source the New York Times is no substitute for getting copyright permission. Where permission is required, you must actually contact the copyright owner or their appointed agent and obtain it. I see this happening a lot in student newspapers, including our own college newspaper, where the paper will use photos and just cite the source, but they didn't actually obtain the copyright permission. Sometimes, to make things even worse, they'll just say that the source is Google, which of course is completely incorrect, because Google isn't where the photo came from. It's just the search engine they used to find the photo. Someone else or some other website is actually hosting the photo and owns the copyright permission for the photo. Second, while the law can be an obstacle and admittedly a bit of a pain, for journalists who want to use copyright material, it's important to remember that your work is protected by copyright law as well. Unless they can make a fair use argument, others who want to use your news stories, pictures, graphics, or other creative works must first contact you for your permission. Finally, while we've hit the important points of copyright law, we've only scratched the surface. It's worth taking the time to learn the rules. Much more information about copyright law is available online through the unusually user-friendly website of the U.S. Copyright Office, and the URL is right there on the screen. Okay, we're almost done. Just a few more important points that we'll discuss briefly. So let's next discuss the Freedom of Information Law. In America, the government is supposed to belong to the people. Freedom of Information laws, which are also sometimes referred to as FOI or FOI, as well as open records laws, open meeting laws, or sunshine laws, are simply one means, a tool by which the citizens or owners of the country have given themselves the ability to keep tabs on or shed some sunshine on what their government and its officials are doing. Although these laws are available for use by all, journalists find them especially useful for informing the public. Even so, far too few journalists, both student and professional, take advantage of the rights that these laws provide. There are 3 main types of freedom of information law. The first are open records laws. Every state, the District of Columbia and Puerto Rico, has its own state open records requirement. In addition, the federal government has an open records law known as the Freedom of Information Act. Similarly, all states in the federal government also have an open meetings law. Finally, there are a number of miscellaneous provisions that show up in various state and federal laws that require the public disclosure of information. These pocket FOI laws generally focus on requiring the disclosure of a specific type of information and, in some cases, only apply to a specific body or institution. For example, at the college level, there are some very helpful provisions tucked within a huge federal education law that requires most schools to provide information about campus crime, student graduation rates, and their athletic programs. In addition, federal IRS rules require that all nonprofit organizations, which includes most private schools like Marist College, make available a copy of their annual tax return upon request something we'll talk about a bit more in a moment. It is important to note that, as a general rule, only public governmental bodies or public agencies must comply with FOI laws. Such bodies are usually funded by taxpayers and have some authority to make or enforce rules that the general public must follow. Purely private individuals or organizations, such as a private school or a private company, are generally not covered. However, if an otherwise private body engages in public business, a court might find that they must also comply with an FOI law. A charter school that contracts with a public school district, for example, might be one example. Keep in mind also that almost all private bodies have some interaction with a public agency, so it may be possible to obtain the information you seek through a back door. For example, while a private school probably doesn't have to give you the result of its most recent cafeteria inspection, the city health department that conducted the inspection, a public body, clearly would have to provide the report. Finally, many of the pocket FOI laws that I mentioned earlier apply equally to public and private bodies and are frequently tied to the receipt of government funding. As mentioned, both the federal government and state governments have freedom of information laws on the books. Generally, if you want to obtain access to the records or meetings of a state or local government agency, such as a public school district, a local or state police department, a state college or university, or the city dog catcher, you'll look to your state law. If you need information about or would like to attend a meeting of a federal agency, such as the Environmental Protection Agency, the FBI, or the U.S. Department of Education, you will use the federal law. Law enforcement agencies can also generally withhold records that might interfere with an ongoing investigation or that might jeopardize national security. And government agencies can often refuse to disclose medical, financial, or other personal documents that would constitute an illegal invasion of a person's privacy. Other common exceptions can include some government personnel records, records involving pending real estate deals, and documents that are part of an ongoing legal battle in which the government agency is involved. Again, because the exemptions vary, you'll need to check the specifics of the law you're using. However, it's important to keep in mind that the law presumes that all government records are open. In other words, you don't have to point to the provision that requires disclosure. Rather, the government has to point to the exemption that allows it to keep the record closed. Law enforcement agencies can also generally withhold records that might interfere with an ongoing investigation or that might jeopardize national security. And government agencies can often refuse to disclose medical, financial, or other personal documents that would constitute an illegal invasion of a person's privacy. Other common exemptions can include some government personnel records, records involving pending real estate deals, and documents that are part of an ongoing legal battle in which the government agency is involved. Again, because the exemptions vary, you'll need to check the specifics of the law you're using. However, it's important to keep in mind that the law presumes that all government records are open. In other words, you don't have to point to the provision that requires disclosure. Rather, the government has to point to the exemption that allows it to keep the record closed. Making a public records request is also pretty much a no-brainer. Simply ask the government official that you think keeps the record for a copy. Ask nicely and politely. A friendly verbal request is often all that's required. Sometimes the government agency or the law will insist that the request be in writing. A written request might also be required where you know the agency you're dealing with does not want to provide the information. In such cases, your written request will be the start of a paper trail of evidence that you might later have to point to should the agency deny your request in violation of the law. Once you make your request, most laws require that the agency official respond in a timely manner and either give you the record you've asked for or point out the exemption in the law that they believe allows them to deny your request. If, after reviewing their denial, you still believe that the law requires disclosure, most laws spell out the procedure for having the agency's decision reviewed. And if you think that filing a written request is too complicated or too much work, think again. Filing a written request is as simple as writing a letter, and there are a number of organizations out there that have put together automated websites that make it easy for you to go and put together an open records request letter. One of them, the Student Press Law Center, has a one-of-a-kind automated letter generator for requesting public records on its website that is pretty useful. To produce the letter and make it ready for mailing, all you need to do is have a reasonable description of the record you're looking for. You don't need a specific document number or exact date, but of course, the more precise your description, the better. You also need the name and the contact information of the government official you believe keeps the record you're looking for, and you're good to go. Okay, so that covers open records laws. Open meeting laws work pretty much the same way. Again, all open meeting laws say pretty much the same thing, that a public body must provide notice of all official gatherings and allow the public to attend unless there is a specific exemption in the law that allows them to keep the doors closed. Many of the exemptions in open meeting laws are the same as those in open records laws. And again, the exemptions vary from law to law, so you'll have to check the specifics of the law you're using. Taking advantage of an open meeting law is usually even easier than using an open records law. You simply just have to show up the meeting you want to attend. Now, if the agency is not used to having visitors sit in on its meetings, you may want to have a copy of the open meeting law available. Again, courtesy counts. Do your best to keep your discussion friendly. If officials still tell you that the meeting is closed, ask that your objection be recorded in the minutes of the meeting and leave. Immediately write down what happened and whom you spoke with. This may also be a good time to get in touch with a media law attorney for help. As with records, most open meeting laws have provisions for appealing agency decisions. For more information on what records or meetings a particular state's law covers, every newsroom in the country should be aware of the publication Tapping Official Secrets by the Reporters Committee for the Freedom of the Press. The 50-state guide is geared specifically to journalists and can provide a quick yes or no answer to many of your questions about what records or meetings are publicly available. It also provides details about your state's legal requirements for complying with the law and practical suggestions for obtaining access. The guide is available free and online on the Reporters Committee website. Finally, in addition to the general open record and open meeting statutes, the law includes a number of provisions scattered about that can accurately be described as FOI laws, or Freedom of Information laws. We already mentioned the laws requiring access to campus crime information. We also touched upon some of the provisions in the Federal Student Right to Know Act, which require most public and private colleges to provide information about how they operate. Of more interest to students, however, is the Family Educational Rights and Privacy Act, which, among other things, requires schools to provide students or their parents with a copy of their own education records, including transcripts, teacher recommendations, and test scores upon request. Also, federal rules require most private schools and other nonprofit organizations to provide a copy of their federal tax return known as the IRS Form 990, which includes information about where money comes from and where it goes, including, for example, a list of the 5 highest paid employees at your school and their salaries. Unfortunately, a detailed discussion of the various pocket Freedom of Information laws is beyond the scope of this presentation. More information can be found on the web. Remember, using Freedom of Information law to obtain information about how your government works is neither rude or nosy. In America, we've decided that we want a government that is ruled by the people, not the other way around. If that idea is going to work, we, the people, must know what our government and government officials are up to. Freedom of Information law is one important means by which that happens. Our 6th topic today is what is collectively known as the reporter's privilege. It includes the right of the press not to be compelled to testify or disclose sources and information to the government or third parties. It also includes the right of journalists to be free from intrusive searches and seizures of their persons and property. Fortunately, it is a problem that comes up fairly infrequently for student media. Unfortunately, however, it's a problem that, when it does come up, often arises in a physically and emotionally charged setting that requires a quick and knowledgeable response. A privilege in law is exactly what it sounds like, something that gives one person an advantage another does not have. Journalists argue that because of their unique and necessary role in providing the public with independent, accurate, and complete information, the law should recognize a privilege that protects them from legal actions that threaten the integrity of their effort and their ability to gather and disseminate the news. Journalists argue that where the government is allowed to confiscate reporters' materials or compel reporters to turn over information they have collected, the public is less likely to view the press as an independent watchdog and more likely to see it as an extension of the government itself. Reporters' privilege cases can arrive in a number of contexts. Most involve an attempt by those in authority to obtain a reporter's notes or other news-gathering material, or to force the reporter to change his role from that of a neutral observer to a witness that provides information for one side or another in a dispute. One of the more common methods of forcing a reporter to provide information is through the use of a subpoena. A subpoena is a court order that requires a person to provide information. Sometimes the information is in the name of a confidential source. Sometimes it is in order to answer questions under oath. At other times, a subpoena requires a person to provide material, such as notes or a photograph. Often it is a combination of the above. Another way to obtain information from a reporter is to simply take it by force. Newsroom searches, confiscation of a reporter's notes or camera, wiretapping of a reporter's phone, tracing his phone calls, tracking a news organization's internet usage, and the outright detention of journalists are other cases where a reporter's privilege claim might arise. So what do you do if you find yourself in one of these situations? In the case of demands to turn over notes or photos or to reveal the identity of a secret source or some other information, it is important to remember that, other than in a few rare emergency-type situations, law enforcement and other government officials have no legal authority to force reporters to disclose such information unless they follow the rules for obtaining and issuing a subpoena. That said, however, if in a face-to-face confrontation with officials, it is usually best for journalists, while clearly voicing their objections, to comply with demands for materials even if they believe the demands are unlawful. Once the immediate confrontation is over, journalists should formally challenge the actions taken against them as soon as possible. I've known more than a few reporters who have refused to surrender the materials to police officers, and when that happened, the police officers responded by physically assaulting them, even tasering them, and of course they ended up getting the notepads or the film from the journalists. And when it comes to school officials wanting access to your journalistic materials, the same principles generally hold true. Absent a properly issued court order or bona fide emergency, school officials generally have no legal authority to force student journalists to turn over their news gathering material or to reveal information they have collected. Unofficial demands made by other third parties, such as business owners, lawyers, or disgruntled readers, can be politely refused or ignored. In addition to responding appropriately to verbal or written demands for material or information, it is also important to know that police, school officials, and others are not permitted to simply show up and physically take a journalist's unpublished work on their own. The law can provide significant protection and recourse against unlawful searches and seizures of journalists' newsrooms and news gathering materials. A federal law, known as the Privacy Protection Act of 1980, and a number of state laws prohibit most newsroom searches, even where police or other government officials produce a search warrant. Such laws, as well as the First Amendment itself, can also prohibit government officials from detaining reporters and demanding that they turn over or destroy their cameras, film, video cards, notes, or other news-gathering material. Additionally, where government officials or other third parties take or destroy a journalist's property without permission or justification, it may be possible to pursue a criminal claim. As already pointed out, until a reporter receives a properly delivered, court-appointed subpoena, he or she is generally under no legal obligation to comply with a demand to turn over material or to provide information to others. Even if you receive a subpoena, however, you may still be able to avoid disclosure. but you must keep in mind the following. First, a subpoena is an official court order. You cannot simply ignore it or hope that it will go away. Carefully note the deadlines for complying with the order and seek legal help from an experienced media law attorney as soon as possible. Failure to respond in a timely, appropriate manner often limits or eliminates your options, and it could land you in legal hot water. Because subpoenas often have a fairly short response time, it is essential that you act quickly. Also keep in mind that after receiving a subpoena, it is against the law to destroy, hide, or alter your notes, electronic data, including email, or any other news gathering material that you believe may be targeted. Finally, and most importantly, know that you have a legal right to challenge the subpoena in court before complying with it. Understanding the risks subpoenas pose to a free and independent press, the media, in particular the student media, have a long and proud tradition of fighting attempts to force their disclosure of confidential sources and material. If you receive a subpoena, there are two primary legal shields that you can use to avoid having to testify or provide other information or material. The first is called, simply enough, a shield law. A shield law is a statute enacted by lawmakers and written specifically to protect journalists from having to comply with subpoena in certain cases. Currently, over 30 states and the District of Columbia have a shield law on the books. There is at present no federal shield law, though Congress continues to seriously debate the matter. Even where lawmakers have not passed a shield law, courts in many states have recognized some kind of reporter's privilege. There are strengths and weaknesses to each type of protection, and they can vary by state. Most shield laws and privileges do not provide absolute protection to journalists in every situation where they might want to keep information or material to themselves. In most cases, a balancing test is used to weigh the need to disclose the information against the public's interest in ensuring a free and independent press. Most courts have found that student journalists have the same protections as their professional counterparts, but there have been a few exceptions. Before making a promise of secrecy to a source, it is important to know and understand what legal protections may or may not be available to you. Because of the urgent nature of a newsroom search or the confiscation of news gathering material, and to a somewhat lesser degree the receipt of a subpoena, it is important to know where to find information when you need it fast. Three good online sources are the Student Press Law Center's Student Media Guide to Protecting Sources and Information, the Student Media Guide to the Privacy Protection Act, and the Reporter's Privilege Compendium published by the Reporters Committee for Freedom of the Press. All are free and provide quick, comprehensive information for help in responding to challenges to your news gathering independence. Finally, no matter what protection the law may or may not offer, always remember that if you make a promise to a source, you must be prepared to keep it. Breaking a promise to a source is a serious ethical breach that violates not only the trust your source has placed in you, but harms journalists everywhere by making it less likely that other sources will come forward with information the public may need to know. Breaking a promise may also constitute a legal violation, as some courts have found assurances of confidentiality to constitute binding legal agreements. A problem unique to student media can arise when a student media advisor, usually a school employee, knows the identity of a confidential source that may be involved in dangerous or illegal activity, such as substance abuse. In such cases, the advisor may have a separate legal obligation to alert other school officials about what he has learned. To avoid the unpleasant conflict between honoring the student media organization's obligation to a source and his professional obligation to reveal information about harmful activity, it is generally best that the advisor not know a source's identity. With all this in mind, and given the risks involved, it should be clear that the promise of confidentiality should always be the exception rather than the rule. So, in other words, avoid using anonymous sources. Okay, so we are now at our seventh and final topic, and that is media law on the internet. And basically there are two things you need to know. Copyright, libel, invasion of privacy, all those topics we just talked about, they all still apply to the internet. And then secondly, Another common issue that comes up is, are bloggers journalists? And legally speaking, no, they're not. At least not in the eyes of many courts and government officials who've been reluctant to give them the same rights and protections that journalists enjoy. After all, anyone with a computer can call himself a blogger, and giving protections and privileges to reckless, untrained hacks could encourage abuses that make life more difficult for real journalists. On the topic of blogging, there's a couple things you should know. First, you do have the right to blog anonymously. The Supreme Court has repeatedly upheld the First Amendment right to speak anonymously, including online, so in things like blogs or on online discussion boards, forums like that. But that doesn't necessarily mean that people won't be able to find out who you are. Just because you're anonymous, there are still ways people can find out your identity. If someone wants to know, for example, which person posted a libelous statement on a website, they can subpoena the website host or the internet service provider, and they may turn over records that reveal your identity. If you have any questions about your rights as a blogger, what you can do and can't do legally speaking, the Electronic Frontier Foundation has written a guide to blogging anonymously that may be of assistance, and the Reporters Without Borders has also written a handbook on how to use technology anonymously. Well, that's it. That is the big 7 legal issues most commonly faced by journalists in a nutshell. Hopefully you now feel a little more confident in being able to recognize and navigate some of the most common trouble zones for journalists, including student journalists. Because if you can spot a potential problem, you can always seek additional help in avoiding it or fixing it. And to that end, I have listed on the screen a few organizations that provide legal assistance to journalists. If you have any questions about today's presentation, don't hesitate to ask me. Feel free to send me an email. So once again, I am Professor Mark Grabowski, and thanks for watching.